Hi everyone, Dr. O'Malley here in Unit 7. We're talking about legal considerations in counseling education. Here's our guiding question of the week. In what ways can legal knowledge and counseling shape the pedagogical approach in counseling education? So, what I kind of want to do this week is I really want to think about different cases that can help you teach students and think about these cases and how you might help teach ethics and the law. The first case is Parasoft versus Regents, the University of California. There was a client who went to psychotherapy and disclosed to the counselor he was thinking about killing someone. We believe in confidentiality. The counselor did report this, but reporting to the police is not enough. The counselor needs to warn anyone affected. This case is interesting. Keep in mind, this was at the California Supreme Court. This is a case that has helped us counselors think about reporting to the police is not enough. If there's someone in immediate danger and we have information that could help, that we have a responsibility to help. Let's talk about Jefferies versus Redmond. Now, this one is interesting because it happened in Illinois, where Redmond was a police officer and ended up killing somebody as a police officer. They claimed self defense. There's always reviews that happen when things like this go down. And then they went and sought psychotherapy, saw a clinical social worker, and during the trial, and here's what's interesting, the trial actually didn't happen in Illinois. It went to federal because the folks representing the Jeffrey estate or the estate of the person that died ended up claiming it to be a civil rights issue, and it went federal. Okay, so in that, the judge tried to get the psychotherapist to testify. The psychotherapist wouldn't, claiming confidentiality. And the judge went ahead and instructed the jury that maybe they are hiding something, testifying. That went up to the Supreme Court in a 6-3 decision. Some conservative members siding against Redmond, saying counselors do have privileged communication. So when you go to teach this one, I think it's really interesting because students will listen to cases like this and be like, oh, we're good. But there still is disagreement, even with a 6-3 decision and the court flipping. Folks need to consider that. What's interesting is even though the state protected them, and then the Supreme Court ended up backing them and saying that, wait, you instructing the jury that they're hiding something because of this being privileged communication is not completely right. It's really interesting. So when you go to teach this in the classroom, I think it's important that we can teach confidentiality, that this is a case in which like confidentiality was upheld. It wasn't upheld without bruises towards the officer. And yeah, it's an interesting case that continues to be used in terms of confidentiality. Let's talk about Ruff versus North Mississippi. So in this case, you had the counselor, Ruff, who was working for an employee assistance program, and they were working with someone that was a part of the LGBTQ plus community. And because of religious values, just didn't feel as if they could work with that client. Okay. So in that, they got terminated. So Ruff went ahead and sued, and it was determined in this case that even though employers do need to look at accommodating religious beliefs, that they don't need to do so if they are seen to be completely inflexible. So this is another case where if you go and look at the details of it, it's not as clear cut as folks would think. Counselors view this as a win, where you need to follow the ACA Code of Ethics. You need to make sure that you're not terminating with a client because of values differences. Inflexibility, this is just my own take, comes to like you can refer based upon competence, but it seems like the counselor and I don't know, go and do your own research on this, was taking some sort of moral stand on this, and we need to put our clients before ourselves. We need to teach our students to work with anyone that walks in, that we cannot go ahead and terminate services because we have values differences. What's interesting about all these cases is that I see students be like, oh, the court ruled and we're right. And if you go look into the case law, it's not as clear cut as people think. So for this one, Walden versus the CDC, it's very similar to the Buff case, right? So, case in the Northern District of Georgia, counselor Walden contracted with an EAP and referred a lesbian client to another counselor, but when they referred them, they explicitly mentioned that the same sex relationship conflicted with their values. The client complained of feeling judged. So the employer actually asked her in the future if she could go ahead and maybe refer without bringing up religious beliefs. The counselor sued for religious discrimination. So when the court looked at this, they focused on the manner in which the counselor handled the situation. For example, expressing judgment rather than the referral. So the counselor Walden lost this case, and it's similar to Buff in that like when we refer a client, how we do it matters. So we can't necessarily pull off of our values. This person might have been in the clear if they went and used the competence argument, but they didn't. So we need to go ahead, if we do refer without judgment, refer without bias. So we need to continuously remind our students that we can't take moral stands with our clients. That's not something we can do. This one, Ward, is an interesting case because this one has to do more with counseling education programs. So this one is something that you should pay attention to. Ward, a graduate student in a creative counseling program, they were actually at Eastern Michigan University, actually asked to refer an LGBTQ plus client in their practicum because they kind of believed that providing gay affirming counseling would violate their religious beliefs. Ward was then dismissed from the program for violating the ACA Code of Ethics and the program policies. From there, the student sued, and she claimed that her First Amendment rights were violated. Initially, a federal court rejected her claim, holding that the university was being reasonable in requiring counseling students to be able to serve gay clients, and it found no violation of her rights. So this is where in that first ruling, counselors and the ACA really celebrated and was like, yeah, this is great. Like, it's affirming what we believe. However, on appeal, the Sixth Circuit sent the case to trial, not as an outright win for Ward, but to examine whether the university had selectively enforced its no referral policy. So this is where what you all need to recognize is what will get you in trouble is the policies that you have, and are you following your policies? The appeal panel noted that the jury could find the university used the ethics code as pretext to punish the student's religious speech if no clear rule action. The case is complex but highly instructive for all of us because it shows how complicated all this is. So while it affirms that programs can enforce ethical standards, it also cautions us to have very clear, uniformed, applied policies. So this case is used as gatekeeping, and don't quote me on this one, but this one is unique because I don't think it went to trial. They settled outside of court. So we didn't get the case law from this one the way that we wanted to. But again, don't quote me on that. Let's talk about this case now, which is a little different, the Kein case. And so with this one, right, what we're looking at is that enforcing ethics in counseling education is important because in this case, counselor Jennifer Keaton actually wanted to use conversion therapy with an LGBTQ plus client, and the faculty required her to complete a remediation plan to remain in the program. The student refused parts of the plan and was dismissed, so she sued, alleging her religious rights were violated. But the court sided with the university. The 11th Circuit Court of Appeals upheld Augustana, that was the university that did this, noting that the student planned approach would actually violate the ACA Code of Ethics by imposing the counselor's values on the client. The university was justified in prohibiting such conduct because gatekeeping is a part of our ACA Code of Ethics. This case highlights that counseling programs must enforce professional ethical standards for client welfare. It has shaped pedagogy by supporting the role of the remediation process in our counseling education programs. I'm giving you a taste of some of the main cases and laws that a lot of your students will wrestle with. One thing that I think is really important is that many times students will look at a case and think it's clear cut. When you go into each of these cases, it's more complex than you think. What's important for our students to realize, and what we have to do as counseling educators, is understand some of the case law. We need to educate our students on the principles of that case law. More importantly, we need them to see the complexity of some of the things that are still in there. The other thing I really want to highlight to all of you as a chair, as an administrator, is how important it is to have clear policies and how you follow those policies. When we send things to our legal department for consultation, half the time they're looking at what we have in our handbook and are we following that. Interested to see what you all think this week? Go ahead and look into these cases and can't wait to see what you all think. Thanks.